So when I was asked to do this, as you may imagine, Brexit was a possibility that was to happen very, very shortly, because we were beginning to organize this at the beginning of 2019, something like this, and 2018? Yeah. And we were waiting for something to happen on March 29. It didn't happen. It's been moved on. We still don't know whether or not it's going to happen, of course. But of course, we also had to change a little bit the trajectory of also this session. We had to change the title, because sometimes it happens. And therefore, when I was called to do this, I was puzzled, because I said, well, what can I say? I knew that Tasha would speak very eloquently about what the government of UK is going to be doing. I knew that Colin would tell us about the point of view of someone that is working on the field here in the UK. So what I could do, I'm from Italy. We're going to stay, unfortunately. No, not unfortunately at all. And therefore, I decided to do something different. I want just to give you a sense of what the UK has been for the European Union. And I think that is very, very important. So this is something that I have to thank our friends from Darts IP. I'm not making any kind of secret advertisements. They were very nice. They gave me a lot of information that allowed me to do this, so I want to thank them, and in special Ludovico for giving me this data. So these are the references that have been sent to the Court of Justice in the past 20, 25 years. Some numbers can be a little bit. I try to stay only on trademarks and maybe design. I didn't look at the patent case, but anyway. So as you may see, the UK has been one of the most active immediately after Germany. Someone says that this is also a result of some kind of laziness by part of the judges, that sometimes they don't want to do their job. They just said, hey, we're going to send it to the Court of Justice and they're going to help us, which not always helps, because as you know, the Court of Justice decision sometimes is very complicated and you really don't know what they want to say. But so when I began to look at this, I began to look at cases that were beginning in 1999, beginning of 2000. The world was totally different at the time. No, we didn't have Facebook, we didn't have social media. We used piece of paper, we used computer, but we didn't use the same kind of thing. So we are beginning to look at these cases which were at that time. I'm going to go very, very fast. You know all of them. But it's interesting to look at them just to remember where we were in 2000 and where we are now, because this also tells us how important it's been in the UK for all of us. So, first case is Davidoff. You remember Davidoff Levi-Strauss? You remember what it was? No, what was the consent, whether or not parallel imports, and whether or not you need an express consent, you don't need an express consent. Now we know what it is, but that was Davidoff. And then we had something about repackaging on trademarks. You know that this is something very important, the fact that we have difference in prices in pharmaceutical has been changing a little bit the landscape, and it's interesting that if now we can assess drugs at a lower price because of this case, and something this allows for repackaging, rebranding, and tell us how to do it to make sure that you don't take a pill that is due for headache and then you get some kind of bad disease because it's bad. What about this other one, the Philips? The three-dimensional trademarks, whether or not. Now, and today we were looking at all these kind of shape marks, and we're looking at the different kind of possibilities than you can have when you are filing a trademark. And this was a very, very interesting case. This was one of the landmark cases that we all know when we were going. I'm sure, I see a lot of young faces. I'm pretty much sure that when you were in law school, you were studying this kind of case, because this was one that told us that no matter what, if there was some kind of element of functionality, the trademark could not be granted, no matter what the acquired distinctiveness you might prove. And what about this? Huh? What about the Arsenal, the post-sale confusion? The Arsenal case, the case of the little guy who was selling the badge of honor, the badge of lawyership to the team, and whether or not this was a possibility that people would take it for the real thing. And they would say, yeah, you know what, even if outside outside is the stadium, no matter what, it can give you the possibility that you may confuse with the real merchandise, and Arsenal is still on the book. La Mer, right? Trademark use, genuine use. Do you remember Ansul? And then we had La Mer, another case which actually helped us a lot. And when we now are in front of UIPO, we have to argue whether or not our trademark has been genuinely used. We have to use this kind of parameter. We have to say whether or not there has been what are market share, a creation or maintaining of market share, all these kind of things. My name is Bond, James Bond. Whether or not a name can be registered. Maybe this was a case that was very interesting, maybe it was particular about the UK, but notwithstanding, this was a case that told us a little bit about the possibility that you might register a name as a trademark. So we now know that we can do these kind of things. We now know how can we do if we have a client who has a particular name and whether or not you can get the registration. And now we go to the big ones of candies, the candy wars. The Nestlé versus Mars. No, the distinctive character, whether or not Kit Kat, whether or not have a break. Let's get a break. We will have a break, by the way, exactly in 8 minutes. And I'm told that you have to come back in 15 minutes because we have another session. So have your break and come back in 15 minutes. That's sharp. The O2. You know what? I didn't know, but when I was researching this, I discovered that O2 has been bought by Telefonica of Spain. I didn't know about this. But apparently at this time, when this was made, O2 was a very, very big brand over here. And they were very, very upset that someone was using their bubbles. You know, bubbles, whether or not bubbles are important. Yeah, apparently they were. And this was one of the first beginning of intersection of trademarks and unfair practices in advertising and all these kind of things. This was a very important case. We do use standards that were developed with this decision until now. The Lancôme, Trésor, L'Allure, the famous brand, whether or not. This is another big one, again, which was very, very important, whether or not you can take an unfair advantage out of certain products just by referring on that, the replica. I mean, these people were not selling their things, but they were copying and they were using it, and this was considered to be a disparagement. Again, we are using this every time we're arguing in front of people, in front of our national courts, no matter what they are. They can be Italian court, German court, French court, whatever it is, we're using this. L'Oréal and eBay. This is another great case. How many times did we pour over these words, try to make a case whether or not we can go after this big platform, the bad ones, the ones they're selling, they're destroying. I saw a beautiful sign coming down, walking from my hotel. It was outside a place that said, whenever you buy a book from Amazon, our shop is closed to be closed, which is something that unfortunately can be part of the modern society. So you remember this one. Interflora, the AdWords, the Mark Spencer. Even this one is a case that we have been studying a lot. And what has told us about whether or not you can be deceived by a website into believing that that website belongs or not to a certain company to another. The Budweiser against the Badoich. On the company names, there was Andreas. I think he was the one who argued this case. And I don't think that he went how he wanted. But, you know, you win some, you lose some. Maybe translator? Do we know anything about this? Does anyone know about this trademark case? What was this about? And I still remember, because it came out in 2012. We were in Palermo having ECTA. And I remember that the decision came the day before. And I remember people of UIPO, they were scrambling all night long, trying to put forward a position in a paper in order to isn't it, Dimitri? How to cope with these. And they come up with the infamous communication 412 by UIPO. Specsavers, whether or not you can use part of these and you can use another form and the color and Specsaver again. And it's interesting, every time I come here I see a Specsaver sign. I say, I know that sign. It's not Specsaver, there is not Specsaver in Italy, for instance. I don't think there is in another country, but I'm pretty much sure that whenever you go around and you see that, you say, I know what is that thing. the little bars. Again, the Kit Kat. You would believe that there are people who have diabetes, how they feel excluded every time they see the kind of things, how much they're fighting over the functionality of the bars. So, very quick, we did it. A lot of what we did came from the UK. And perhaps, or possibly, because their system was slightly different from our, the place they were coming, their laws were a little bit different, they had to ask sometimes questions that maybe other judges did not have the guts to ask to the Court of Justice. But thanks to the UK, thanks to the EU courts, and thanks to the especially, most importantly, thanks to the UK lawyers who went to argue this case in front of the Court of Justice. The trademark law that we're doing, and I just stay on the trademark, but there are also other cases, as a case in the same design. But our laws, the laws that we will continue to apply, even after, if it happens, they go away, has been shaped a lot by our courageous hosts. So I will conclude. I conclude with two little things. It's a kind of present that they are leaving us. These are two references to the Court of Justice that are now pending. One is the Neve case, which has to do with jurisdiction. Basically, someone was selling from Spain to England. He was sued in England, and the British judge said, do I have jurisdiction? Something is put up on Spain, and the transaction is on Spain, even though it might have an influx on the UK consumer. And how do you assess whether or not? I mean, if I'm pretty much sure that our US colleagues, they know these kind of things, because jurisdiction and how the long arm of reaching out of your state, it's something that has been discussed a lot in the United States. But in Europe, not yet. So this case is going to tell us, and it's going to give us guidance on whether or not you can sue someone depending on where the act is taking place. So these are the questions. You will find these. These are very dense. I don't want to go to. You're going to find these at the end. At the end, you can go in the website and you can download this presentation with all these kind of questions. So this is what the AG opined. He gave a very good opinion. I think the Court of Justice might follow this. So it's giving some kind of parameters on how you can assess whether or not a judge can have jurisdiction. And then the Sky versus the Sky Kick. This is another reference. This one has not arrived yet at the stage of the Advocate General, but this is an incredibly important case. This is another IP translator, because this is going to whether or not using certain terms can be imprecise. And in this particular case, these were going for software. And they were saying, is computer software too vague, whether it's general enough? And we know, personally, I know that there are certain software that are used to do certain things, and there's software using totally different other things. Are they really similar because they're only software? Maybe, maybe not. And is it bad fate to file registration where you put everything? You just throw it there. I don't know, but you've seen, certainly after being translator, there is this application that are pages and pages and pages and pages, and there is everything that can be taken out of the NIST classification. Is that bad faith? Is there any intent to use these kind of things? And if you're doing, is this something that was really not what the legislator intended or what the court intended in a Peter Translator when they said that it had to be clear, concise, and self-contained, and blah, blah, blah? I don't know. We will see. And this is a present that the UK has left to us, because I don't think that even if you were to leave, which I hope you won't, that the Court of Justice says, oh, these are references from UK court, so they're no longer important, so we just don't rule on that. I'm pretty much sure they will rule out. So even after, if that happens, we will be thankful for them, for something that's going to help us, our work. So how can I finish my speech? Oh, these are the outcomes of the case that I refer. This is how I finish. Good luck. Thanks for everything. I will miss you. And I hope that you will miss them too. The session is over. Come back in 15 minutes, please.